Chevron versus Natural Resources Defense Council is a 1984 case that set forth a two-step test for determining the scope of an agency's authority to issue rules. If the statute is clear, then the analysis stops there. But if the statute is ambiguous, then the court has to defer to the agency's interpretation of the statute if the agency's interpretation is a reasonable one. The central question in the Loper Bright case was, should Chevron be overruled? There were two sets of petitioners consolidated together. Both of these cases involved fishing. The Department of Commerce had issued a rule saying that fishers of this type of herring had to put a monitor on their boats. Basically, the federally acquired monitors would watch everything the fishers did. Having this monitor there wasn't cheap. There were estimates in the briefs that having these monitors there cost the fishers about $710 per day. The statute that regulates this was silent on whether fishers of Atlantic herring had to have this type of monitor. Other parts of the statute said that fishers who catch different types of fish had to have these monitors, but not these herring fishers. And so the question was, is the agency allowed to step into this silence and issue a rule requiring these monitors? Chief Justice Roberts' majority opinion is very clear and very methodical. There's not a lot of literary flourish, not a lot of flights of fancy in his prose. He just walks through the history of judicial review in our system, walks through the history of Chevron, methodically explains why it's not really rooted in our law, and he makes his case quietly, subtly, and powerfully. His analysis, as I read it, is more focused on Section 706 of the APA. Section 706 of the APA provides that it is the job of judges to say what the law is in these cases. Chief Justice Roberts looked at that language and said, well, Chevron turns that statutory language on its head. Instead of judges looking at these statutes like this fishing statute and saying, okay, what does the statute really mean as applied to these people who catch herring? What Chevron requires judges to do is to throw up their hands and say, okay, if this language isn't perfectly clear, we have to just put a thumb on the scale for the government. That's not what the APA says judges are supposed to do. Thomas really wanted to address the separation of powers concerns with Chevron. Gorsuch wanted to discuss why Chevron shouldn't qualify as stare decisis, why it nonetheless made sense to overrule that precedent. Kagan sees Chevron as a foundational part of the law, and she sees it as important to have a tool that allows deference and requires even deference to agencies. The biggest takeaway of Loper Bright is that it overruled the Chevron doctrine that had come under fire for many years. Courts are no longer required to tip their hand to the government. They're no longer required to put a thumb on the scale for the government in these cases. I don't think that that means that this is going to completely destroy the regulatory state and that it'll make it harder for the government to engage in certain kinds of overreach. If the American people want regulation in a particular area, Congress has to speak clearly to the type of regulation that there will be. Agencies can't regulate by stealth, can't regulate by stepping into gaps or ambiguities.